Salient features of the British Constitution. Introduction. A constitution means certain principles on which the government of the state is organised and which establish relations between the people and the government. The British Constitution is unique in nature. It is constantly growing and changing. Salient features of the British Constitution. The following are the salient features of the British Constitution. A. Unwritten. In nature, the British Constitution is unwritten, but that does not mean that all of its parts are unwritten. It means that it has not been reduced to writing in a single document. Besides the same fact, some of the components are found in written form. B. Evolutionary growth. The British Constitution is the result of evolutionary growth. It is not the product of any express legislative act or acts. The British Constitution is a product of evolution. It is not a complete thing, but a process of growth. C. Flexible. The British Constitution is a flexible constitution. The British Parliament can amend the Constitution by ordinary legislative procedure and by a simple majority. It's because of the absence of specific procedures required for the amendment of the Constitution. D. Unitary Constitution. The British Constitution has a unitary character. All powers of the state are concentrated in the hands of a single government for the whole country. There are no units or states in Britain. E. Bicameralism. The British Parliament consists of two chambers, that is, the House of Lords and the House of Commons. The House of Commons is the lower chamber of Parliament. It is a popular chamber whose members are directly elected by the people. On the other hand, the House of Lords is the upper chamber. It is basically a hereditary chamber, and its members are nominated by the Queen or King. F. Supremacy of the Parliament. Parliament is supreme and sovereign in England. Its command is law, and it is final. No court in the country can challenge the validity of laws passed by Parliament. In the words of Delorme, British Parliament can do everything except to make a man into a woman and vice versa. G. Collective responsibility. Ministers must stand together, and they cannot oppose governmental policy. Every minister is also individually responsible for the House of Commons and the Crown. H. Two-party system. The presence of a two-party system has been credited with establishing the English political system. The two-party system flourished in Britain right from the beginning of the parliamentary period. J. Rule of law. The rule of law may be defined as the fact that none of the people are above or below the law. What is the law for one is also the law for the other. All people are equal in the eyes of the law. If any person violates the law, he should face trial in the government court. No person can be punished unless and until it is definitely proven that he has violated some law of the country. K. Fundamental rights. The fundamental rights of the citizens have not been incorporated in the form of a list in the British Constitution. The freedoms of the Englishman are guaranteed by the ordinary law of the land. The British Constitution is not the creator but a product of fundamental rights, which have been recognised from time to time by the courts. L. Checks and balances. The British Constitution is also based on the principle of checks and balances. For example, the two houses of Parliament can pass a law, but no new law can be enforced until it is signed by the King or Queen. Likewise, no order of the Crown is valid unless and until it is countersigned by the concerned ministry of the country. M. Unreality. Unreality is another characteristic of the English Constitution. There is a great difference between the appearance and reality of the Constitution. For example, it is an absolute monarchy in theory, but in reality, the same theory is not functional. It is now a democratic state ruled by a parliament elected by the people. N. Mixed constitution. The British Constitution is a mixture of monarchical, aristocratic, and democratic principles. In other words, we can say it like this: The British Constitution is a mixture of absolute and limited monarchy. O. Limited monarch. In England, monarchy is limited in nature. The powers of the king have been taken away through statutes and conventions, and those are being exercised by the ministers in the name of the Crown. At present, the Crown can do nothing without the advice and consent of the Ministry. P. Universal adult suffrage, right to vote. Every individual over the age of 18 has the right to vote. Q. Conservativeness. The British Constitution is a symbol of conservatism. The trend of the people of the UK is absolutely in favour of old institutions, and this concept is the existence of conservatism. R. Independence of the judiciary. The British Constitution is not based on the theory of strict separation of powers, yet by convention and tradition, a lot of independence has been allowed to the judiciary. Judges of the British Constitution. Introduction. The British Constitution is not found in one document. It consists of different elements that are scattered. The British Constitution is unique in nature and is constantly growing. It came into existence with the passage of time. It can only be understood by reference to a long series of acts, traditions, and judicial decisions. Sources of the British Constitution. Following are the sources of the British Constitution. A. Constitutional landmarks. A constitutional landmark is a combination of documents, charters, and laws. This came into existence in the form of agreements, contracts, treaties, or recognition of rules by Parliament. For example, the Magna Carta of 1215, Petition of Rights of 1628, Bill of Rights of 1789, Act of Settlement of 1701, and Parliament Act of 1911. B. Statutes. According to the requirements of the people and demands of the government, the UK Parliament formulated the law, which not only played a vital role in the source of the Constitution but also delivered coordination among the institutions of government. The following are the important includes in the sources of the UK Constitution. 1. The Habeas Corpus Act, 1671. 2. The Municipal Corporation Act 1716. 3. The Reforms Act 1867. 4. The Judicature Act 1873. 5. The Representation of People Act 1918. 6. The Ministry of Crown Act 1937. C. Common law. Common law may be defined as those rules that are the product of a slow process of long historical growth and are based on customs and traditions. These principles are not set down in any statute or ordinance. The courts recognize these principles. The prerogatives of the Crown, the right to trial by jury, and the right to freedom of speech rest almost entirely on common law. D. Judicial decisions. Another source of the UK Constitution is to be found in judicial decisions. Judicial decisions are the judgments and interpretations of courts, which define the scope and limitations of the different charters, statutes, and common law. E. Conventions. A substantial portion of the UK Constitution is based on convention. These are not codified in any book of law. The courts do not enforce conventions, but these rules are recognized by the Constitution. F. Important conventions. Following are some of the important conventions. 1. The Crown has no power to veto a bill passed by both houses. 2. Parliament must be summoned once a year. 3. Prime Minister will be from the House of Commons. G. Opinions of jurists. The opinions of jurists are also an important source for the UK Constitution. The jurists express their opinions in consultation with customs, traditions, judicial decisions, and statutes. Some of the important books of different jurists are as follows. 1. Austin's Law and the Customs of the Constitution. 2. Dicey's Law of the Constitution. 3. Lord Halsbury's Commentary on the UK Constitution. H. Statutory rules made by various authorities. There are various authorities empowered to legislate under parliamentary acts, like universities and municipal bodies. The laws and rules made by these authorities are part of the UK Constitution of the House of Commons in the British Parliament. Introduction. The Parliament of England is called the mother of all other parliaments in the world. When we speak of the British Parliament, we mean the House of Commons. The House of Commons is the lower chamber of the British Parliament. It is known as the popular chamber as well. It is more powerful and influential than the House of Lords or the upper chamber. For all practical purposes, the House of Commons is the British Parliament. In the words of Walpole, when a minister consults Parliament, he in fact consults the House of Commons. When the Queen dissolves Parliament, she dissolves the House of Commons. In other words, a new Parliament is simply a new House of Commons. Composition. At present, the House of Commons consists of 635 members. There are 516 members of England, 71 for Scotland, 36 for Wales, and 12 for Northern Ireland. Qualification of members. The following are the qualifications required for a person to become a member of the House of Commons. A. The person must be 25 years old. B. He must not be corrupt. C. He must not be an insane person. D. Clergymen, civil servants, members of the regular armed forces, policemen, judicial officers, and members of the House of Lords are disqualified from being members of the House of Commons. A popularly elected legislative chamber. The House of Commons is elected directly by the people. But in history, the story is quite different from the present situation. In medieval days, when the foundation of the House of Commons was laid, the House was represented by landlords, merchants, guildsmen, etc. It was a functional representation, not a territorial representation. It continued to be so until 1932. The change came with the extension of the parliamentary franchise through the Reforms Acts of 1832, 67, 84, 1918, and 1928. Women were granted the right to vote for the first time in 1918. In 1928, men and women were granted equal rights to vote. Term of the House of Commons. The term of the House of Commons was 3 years up to 1716, from then up to 1911, it was 7 years. The Parliament Act of 1911 fixed it at 5 years. The officers of the House of Commons. Following are the officers of the House of Commons who perform their specific duties. A. Speaker. At one time, the Speaker used to be the King's nominee, but now the House elects its Speaker, although the Sovereign still formally approves of the Speaker's election. B. The Chairman of the Committee of Ways and Means. He has 3 main functions: 1. To act as deputy to the Speaker. 2. To preside over the Committee of the whole House. 3. To supervise all private business. There is also a deputy chairman. C. The Sergeant of Arms. He is appointed by the Crown to attend to the Speaker, to enforce the order of the House, and to execute warrants issued by the Crown to assist the Speaker. D. Clerk of the House. He is appointed by the Crown to assist the Speaker. E. Chaplain. He is appointed by the Speaker to conduct prayers at the beginning of each session. Committees of the House of Commons. There are 5 different types of committees in the House of Commons. A. Committee of the whole House. B. Select Committee. C. Standing Committee. D. Private Bills Committees. E. Joint Committees. Privileges of members. These are those rights without which the members cannot discharge their function. The members enjoy freedom of speech in the House, and such freedom is absolute. The House can punish its members and outsiders for contempt, disrespect, of the House, Powers and functions of the House of Commons. The powers and functions of the House of Commons are listed below. A. The House as a legislature. All bills that become acts of Parliament must be passed by the House of Commons. In actual practice, the House of Commons has lost its law-making power to the Cabinet. B. The House as controller of the national purse. The powers of the House of Commons over national income and expenditure are absolute. The Parliament Act of 1911 rendered the House of Lords powerless in this regard. C. The House as the maker of the government. The principal function of the House of Commons is to support and vote out governments. As we can say, the House of Commons can, at any moment, choose a ruler as well as dismiss a ruler. The existing role of the House. The existing role of the House is reflected below. A. Function of supporting the government. An essential function of the House of Commons these days is to provide the necessary support to the government to enable it to carry through its Parliament programme. This function is performed by the majority party in the House because the government belongs to this party. B. The function of criticism. Another function of the House of Commons is to criticise the government. The opposition party or parties perform the function. The question hour is another device to bring to light the failures of government in specific spheres, areas, of activity. C. Function of education. The House of Commons, through the wide publicity of its debates in the press and on radio and television, spreads political education among the people. D. Debating issues of political importance. The most important function of the Parliament is the debating of various bills and resolutions that are placed before it for approval. E. Amendment of the Constitution. The House of Commons is fully authorized to amend any provision of the Constitution by a simple majority whenever it likes. F. Redress of public grievances, complaints. The House of Commons is also regarded as the final authority to provide relief to the people when they suffer any difficulty or meet injustice at the hands of government officials. An hour is fixed for asking questions each day. Composition and role of the House of Lords. Introduction. The House of Lords is the second or upper chamber of the British Parliament. Historically, it is the oldest legislative chamber in the world. Its membership is not fixed. Its members are not elected directly by the people, they are appointed by the King or Queen. It is a permanent house that is never dissolved. It is generally stated that the House of Lords is a hereditary house. Composition. Members of the House of Lords are listed below. A. Princes of royal blood. Male adult members of the royal family who have attained maturity and fulfillment are required by the House and are appointed as members of the House of Lords. They, by custom, do not take part in the proceedings of the House. Generally, their number is not more than 2 or 3 at a time. B. Hereditary lords. Historically, this category included landlords and powerful people on the land. About 9/10 of the total number of members belong to this category. The Crown grants peerage, and he may create as many peers as he likes. C. Scottish peers. Scottish peers are 16 in number and are elected by hereditary peers of Scotland for each Parliament. D. Irish peers. By the Act of 1800 for the Union of Great Britain and Ireland, the Irish peers were entitled to elect 28 peers for life to represent them in the House of Lords. Since the establishment of the Irish Free State in 1921, no new peers have been elected. E. Lord of Appeal. The House of Lords is the highest court of appeal in England. So it is necessary that it always contains a number of eminent judges and lawyers. There are 9 law lords who are appointed for life and paid salaries. Their duty is to assist the House in the performance of its judicial functions. F. Spiritual peers. 2 archbishops and 24 senior bishops are the representatives of the Church. They retain or hold their seat in the House of Lords as long as they remain in church services. G. Life peers. They are the people who have held high offices in the state and have since retired, for example, ex-ministers, ex-speakers, ex-politicians, ex-scientists, ex-bishops, ex-judges, and distinguished scholars. Numbers of members. The number of members is not fixed. At present, there are 778 members who are called peers. Their number is added from time to time by new creations. Disqualification. The following persons cannot become members of the House of Lords. A. Minor. B. Convict. C. Insane. D. Bankrupt. E. Woman. F. Present member of the House of Commons. Presiding officer. The House of Lords is presided over by a Lord Chancellor who is a member of the Cabinet. Privileges. The privileges available to the House of Lords are as follows. A. Access to the Crown. Every member of the House of Lords can access the Sovereign, the Crown, to discuss public affairs. B. Freedom of speech. The Lords can express their views freely and without any pressure. C. Right to publish opinion. The Lords can publish their opinions in official papers. D. Freedom from arrest. No member can be arrested when Parliament is in session. E. Exemption. It enjoys an exemption from serving as jurors. F. Determination of peerage. The House has the right to determine disputed claims to the peerage. G. Right to receive writs of summons. They have the right to receive individual writs of summons to attend Parliament. H. Right to record protest. The members of the House of Lords have the right to record a protest against any decision of the majority of the House in the journals. J. Right to act as a court. The peers have the right to act as a court of final appeal. Powers and functions. The House of Lords is both a coordinated branch of Parliament and literally a court of law. It is ordinarily described as the highest court of appeal. Its powers and functions can be explained in different categories. Details are given as follows. A. Legislative powers. The most important function of the British Parliament is to enact laws. An ordinary bill can be introduced in any of the two houses. Money bills can be introduced only in the House of Commons. An ordinary bill passed by the House of Commons is sent to the House of Lords, and when it is passed by it, it goes for royal assent. If the House of Lords refuses to pass an ordinary bill and sends it back to the House of Commons, the House of Commons passes it again, and in between these two passings, a period of 1 year lapses, so the cost of the House of Lords is not necessary. On the other hand, if any ordinary bill is introduced in the House of Lords and the House of Commons refuses to pass it, the bill will die. To be brief, in legislative spheres, the House of Lords is only a delaying chamber. B. Financial powers. In the financial field, the powers of the House of Lords are less than those of the House of Commons. Money bills, according to the Parliament Act of 1911, can only be introduced in the House of Commons. Whether the House of Lords passes it or not, after the passage of 1 month, the bill will go for royal assent. The House of Lords cannot reject it, they can only delay the passage of the money bill by 1 month alone. C. Executive powers. The Lords have the power to ask questions of the government and have a full right to debate its policies. It also enjoys a share of cabinet membership. But they can only examine cabinet ministers, they cannot pass any disapproval against them. The Prime Minister belongs to the House of Commons, as the cabinet is collectively responsible to the House alone. We can say that the House of Lords' control over the executive is insignificant. D. Judicial powers. The House of Lords is the final court of appeal in Britain, and the Lord the Chancellor also acts as the Chief Justice of the country. All peers have the right to hear appeals, but in practice, they are headed by law lords. The whole House never meets a court of appeal. E. Other powers. The House of Lords performs an important function by discussing social and political questions, that are not ready for legislation under the British Constitution. Introduction. Rule of law means the supremacy or dominance of law. The rule of law in England is the outcome of centuries of development. According to Professor Dicey, though there is no separate act in England to guarantee the fundamental rights of the citizens, as is the case in the USA, British citizens enjoy maximum liberty due to the rule of law. The very root of English law depends on the rule of law. Meanings of the rule of law. A. Black's Law Dictionary. Rule of law means a substantive legal principle. B. According to Bluntly, rule of law means that the law of England rules the country and not the arbitrary will of any individual. The law is supreme, and no one can claim exemption or immunity from it. C. General meanings. The rule of law implies that no one is above or below the law. All people are equal in the eyes of the law. If any person violates the law, he should face the case in court. Dicey's exposition of the rule of law. The English jurist Dicey has given a description of the conception of the rule of law in his book Law of the Constitution, first published in 1885. He gave the following meanings to this concept. A. No arbitrary punishment. No man is punishable or can be lawfully made to suffer in body or goods except for a distinct breach of law established by the ordinary court of the land. So all persons accused of an offence should be tried in an ordinary court of law in an ordinary legal manner, and no one is to be deprived of his life, liberty, or property. B. Before law equality, equality in the eye of law. Secondly, the rule of law implies that in the United Kingdom, every citizen, rich or poor, high or low, is subject to the same direction and the same courts of law. It's because UK law does not distinguish between acts of government and those of ordinary citizens. If any public official does any wrong to an individual or exceeds the power vested in him by law, he can be sued in an ordinary court. C. Judicial decisions. Finally, the rule of law means that the general principle of the Constitution are the result of judicial decisions determining, formatting, the rights of private persons in particular cases brought before the courts. Instances, examples, of the rule of law. The following are important instances of the rule of law. A. The right to personal freedom. People have personal freedom in England. No person can be arrested without lawful reasons. B. The right to freedom of decision. The people of England have the right to freedom of decision. The media is independent. Everyone can criticize the policies of the government. C. The right to a public meeting. People have the right to attend public meetings and form political parties. D. Ministerial responsibility. Ministerial responsibility is an important instance of the theory of the rule of law. If one minister does wrong, others become responsible for his actions. Exception. Since Dicey explained the concept of the rule of law, many changes have come over the world, and even in Britain, a country that can boast of the rule of law, the concept had to face the challenge of the changing times and admit certain clear limitations. Following are the exceptions to the rule of law. A. Suspension of the rule of law. During an emergency, the government may partially suspend the rule of law. B. Judges of the courts. Judges cannot be held responsible for anything they do in the official course of their business. C. Queen is above law. The Queen is not amenable to any court of law. She is above the law. She is immune, protected, from all civil and criminal traits, character. The Crown is not responsible for the wrongs done by its officers. The Crown is not responsible for the wrongs done by its officers. A government official is personally responsible for the mistake made in his official capacity. E. Foreign rulers. Foreign rulers cannot be tried by any court in England for any wrong committed by them. F. Diplomatic representatives. Diplomatic representatives cannot be tried by any court in England. G. Servants of the Crown have no protection if dismissed. If the Crown dismisses his servants, they have no protection against the Crown, even though they are dismissed without just cause. H. Public officers. Public officers are not liable for their subordinates' wrongs because certain acts have conferred some privileges and immunities on public authorities. J. Time of proceedings against the servant. It is essential to take action against public servants within 6 months from the date of the cause of action regarding any excess, neglect, or default of public authority. The right of action expires after 6 months. K. Justice of peace. The justice of the peace is not liable for any act if the act is not wrongful or malicious. L. Trade union. Trade unions in England enjoy a lot of immunity, protection, from the law. M. Cancellation of citizenship. If the citizenship of someone is revoked, it cannot be challenged in any court. N. Power to the police. The Public Order Act of 1916 gave the police the power to regulate or prohibit public meetings and processions, marches or parades. It can also declare drilling and the wearing of unauthorized uniforms illegal. Judicial system of England. Introduction. In England, justice is available to all people, whether they are rich or poor. This is due to the independence of the judiciary and the rule of law. When we talk about the judicial functions of the British Parliament, we mean the judicial functions of the House of Lords. The rights and liberty of every individual are protected by the judiciary in England. Salient features. The following are the salient features of the British judicial system. A. Rule of law. The rule of law is an outstanding feature of the British judicial system. It means that none of the persons is above or below the law, and all persons are equal in the eyes of the law. Courts will apply the same law on all subjects. B. Speedy justice. Speedy justice is another feature of the UK judicial system. Cases are disposed of quickly. It is because judges possess greater discretion, carefulness or judgment, in dealing with legal technicalities, and judicial rules of procedure are made by a special rule committee. C. Independence of the judiciary. The courts of the UK are free from all the pressures and decide the cases on merits. D. Neutrality. The courts are neutral in the UK, and they never support any party, plaintiff or defendant. The courts complete the requirements of justice in a neutral manner. E. Equality. The courts in the UK represent the principle of equality. It is the duty of the prosecution to prove its case beyond a reasonable doubt and on its own merits. F. Jury system. The jury system is another unique feature of the British judiciary. In all serious criminal cases, the accused must be tried not by a judge alone but also by a jury, which is a group of laymen who are appointed to assist the judges in the administration of justice. In all civil cases involving an accusation against the moral character of either of the parties, that party may demand a verdict decision by a jury. G. Dual system of bar. In the UK, the lawyers are divided into two parties: the solicitors and the barristers. While the solicitors deal with the clients and prepare cases, it is the barristers who argue them in court. H. No judicial review. Courts in England have no powers of judicial review. On account of the sovereignty of Parliament, the institution of judicial review does not exist in England. No court of law can declare ultra vires a law passed by the British Parliament on account of its unconstitutionality. The organisation of courts in England. The courts in England are divided into two branches, the civil courts and the criminal courts. Comprehensive details on the subject matter are listed below. A. Civil courts. Civil courts deal with private law or disputes between one citizen and another. The organisation of the civil courts in England is reflected below. 1. County courts. At the bottom of the civil courts is the county court. The whole country is divided into about 337 counties, and each county has a court. A county court has one or more circuit judges, assigned by the Lord Chancellor. 2. High Court of Justice. It is located in London. It is an appellate court against the decisions of county courts. The cases that don't fall under the jurisdiction of county courts are referred to the High Court of Justice. The High Court of Justice, also known as the Supreme Court of Judicature, is divided into 3 divisions. A. Queen's Bench Division. The Queen's Bench Division deals with ordinary civil cases. B. Chancery Division. The Chancery deals with cases of equity. C. Probate, Divorce, and Admiralty Division. This division deals with cases of marriage, wills, and ships. 3. House of Lords. The House of Lords is the highest court of appeals in civil matters. It consists of 10 Lords of Appeal in ordinary. 4. Court of Appeal. Appeals from county courts and the 3 divisions of the High Courts of Justice lie with the Court of Appeal. The presiding judge is called the Master of the Roll. It consists of 14 Lord Justices of Appeal, a Lord Chancellor, and all 3 presidents of the Bench Division of the High Court of Justice. B. Criminal Courts. Criminal courts deal with branches of public law. The organization of criminal courts are distributed as follows. 1. Justice of Peace and Stipendiary Magistrates. At the lowest level of the criminal courts is the Justice of the Peace and Stipendiary Magistrate. The honorary judges are appointed in the various localities to decide criminal cases of a petty nature. These judges are called Justices of the Peace. 2. The Court of Assizes. These are the local courts to try criminal cases and are branches of the High Court. Cases in these courts are heard by a judge and a jury. The president of this court is a judge of the High Court. This court is conducted in each county twice a year. It has jurisdiction over various heinous offences, such as imprisonment or death. 3. The Quarter Session Courts. This court consists of all the justices of the peace in a county. All the justices may or may not participate in a session of this court, but 2 justices are necessary to constitute a quorum. Cases involving death sentences or other very serious cases are not headed by this court. 4. Courts of Criminal Appeal. Appeals from the Quarter Session and Assizes lie with the Court of Criminal Appeal. This court consists of the Lord Chief Justice and the judges of the Queen's Bench. 3 general judges heard the appeal. 5. Judicial Committee of the Privy Council. It reviews cases referred to it by various British colonies. In fact, it does not decide cases but gives advice to the King under the British Constitution. Introduction. The Cabinet is the core of the British parliamentary form of government and is its chief guiding authority. Cabinet has been rightly described as the glory of the Constitution. According to Murray, the Cabinet is a term recognised by convention to describe the group of ministers chosen by the Prime Minister who are collectively responsible for formulating policy and controlling the departments subject to parliamentary approval. Evolution of the Cabinet system. Originally, the Cabinet was a committee of the Privy Council, which became too large for administration work. The Cabinet is called the child of the Privy Council. King Charles II, 1668–85, began to consult a small group of Privy Councillors in matters of state. In the reign of Charles II, the Cabinet acquired a formal shape. The Cabinet system was further developed during the reign of William III and Queen Anne. Nature of the British Cabinet. The Cabinet is a body unrecognised by law. Its existence is only customary, that is, based on custom or convention. Composition of the British Cabinet. The Cabinet is the driving force of the administration. At the end of the general elections, the King or Queen invites the leader of the majority party in the House of Commons, who then becomes the Prime Minister, and the Crown asks him to form the Cabinet. Features of the Cabinet system. England has a parliamentary government where the king is the nominal and constitutional head of the executive. The real powers are exercised by the parliament. There are certain essential features according to which the cabinet system is being carried out. The important features of the cabinet system of Great Britain are: A. Exclusion of the king from the cabinet. The Queen of the Kings does not attend the cabinet meeting. It has become a constitutional convention. B. Leadership of the Prime Minister. The Prime Minister plays a dominant role in the cabinet. The cabinet is formed by the Prime Minister. He is the keystone of the cabinet arch. C. Secrecy. The meetings of the cabinet are secret and private. Every member of the cabinet takes the oath of secrecy. The discussion is not disclosed to the public. D. No legal status. The British cabinet has no legal status. There is no mention of a cabinet in the written part of the Constitution. The cabinet is called the child of the conventions. E. Ministerial responsibility. The cabinet members are responsible to the House of Commons individually as well as collectively, and they are liable to the law for their acts. F. Unity of cabinet. Unity in the cabinet is an outstanding feature of the British cabinet system. The cabinet always acts as a unit. They are supposed to face the House with one voice. G. Collective responsibility. The members are collectively responsible. The result is that all the members work as a team. The cabinet stands or falls together as a unit. Function of the British cabinet. Following are the important functions of the British cabinet. A. Policy determining functions. The cabinet is a policy-forming body. The cabinet discusses and decides on all sorts of national and international problems. The cabinet decides which measures will receive priority. B. Executive function. In England, the cabinet is the real executive. The cabinet formulates the general policy of the government. It determines the foreign policy of the government and decides measures for war and peace. All important appointments are made by the cabinet. C. Legislative functions. The cabinet controls legislative activities. The following are the main legislative functions. 1. The Parliament is summoned by the King on the advice of the cabinet. 2. The speech of the King in Parliament is prepared by the cabinet. 3. The cabinet explains all bills that are to be passed in Parliament. 4. The cabinet guides the leader of the House in Parliament. D. Financial function. The cabinet plays an important role in this regard. It prepares the budget for the country and is responsible for the whole expenditure of the stock. E. Judicial functions. Following are the judicial functions of the British cabinet. 1. The judges of important courts are appointed by the King on the advice of the cabinet. 2. The rules and regulations for the judiciary are prepared by the cabinet. 3. The power of pardon, reprieve, and respite is exercised by the King on the advice of the cabinet. System of the English Parliament. Introduction. The committee system involves referring legislative measures to a number of committees for mature deliberation and speedy disposal. Much of the work of the House is done through the committees. Members of Parliament have neither the time nor the special knowledge to discuss the details of all bills that come before the House. The committee system is employed by all the legislatures in the world. Reason for the committee system. The following are the reasons that led to the increased use of the committee. A. The House of Commons is a huge body, and the true purpose of measures introduced in the House cannot be properly understood unless it assigns preliminary work to certain committees. B. Complications in the legislation and the desire of the members to speak. C. The great pressure of legislative work, which cannot be furnished without help from a small committee. Selection of committees. All the committees, excluding the committees of the whole House, are selected by the Committee of Selection. The members of the committee are chosen at a conference between the government and opposition leaders. Kinds of committees. The committees of the House of Commons are of 5 main types. Details are given below. A. The Committee of the Whole House. It consists of all the members of the House of Commons. The chairman of the committee chosen at the beginning of each parliament presides. Following are the features that distinguish it from the sittings of the House itself. 1. A member can speak as many times as he likes. They are allowed to speak any number of times on the same question. 2. No closure motion can be moved. 3. The rules of procedure are relaxed. 4. The mace, which is the symbol of the Speaker's authority, is placed under the table. 5. When the work of the committee is finished, the chairman leaves the chair and the Speaker resumes his duties. Types of committees of the whole House. The different types of committees of the whole House are reflected in the following headings. 1. Ordinary Committee of the whole House on a bill. It comes into being when the House resolves that any ordinary bill shall go to the Committee of the Whole rather than to a standing committee or a select committee. 2. Committee of the whole House on a money resolution. It deals with financial legislation. 4. Committee of Ways and Means. It comes into being to consider revenue measures. B. Standing Committee. It is an important committee, and almost all public bills except money bills go upstairs to a standing committee. Standing committees are 5, one of which is exclusively for Scottish bills, and the other 4 are known alphabetically as A, B, C, and D. The chairman of the standing committee is appointed by the Speaker out of a panel of chairmanships. Each standing committee consists of 20 regular members. But for the consideration of any particular bill, another 20 to 30 members can be added to its membership. The Scottish Committee consists of all members from Scotland. C. Select Committee. The function of the Select Committee is to discuss special bills. They are appointed to consider and report on specific measures that involve some new principles. The committee has the power to collect evidence, examine witnesses, or obtain other necessary information and report it to the House. The Selection Committee sets its own chairman. A Select Committee usually consists of 15 members. These are created from time to time and come to an end when their purpose is fulfilled. The Select Committees are also called Ad Hoc Committees. D. Private Bills Committee. A Private Bills Committee is appointed to dispose of the private bill in Parliament. It works quite impartially, and its report, whether for or against the bill, is always accepted by the House. In the House of Commons, the number of members of a Private Bill Committee is 4, while in the House of Lords, it is 5. E. Joint Committees. The joint committees consist of members from both Houses of Parliament. They mutually consult and consider the bill in a collective way that relates to both functions of the British Prime Minister. Introduction. The Cabinet is the real ruler of Britain, and the Prime Minister is a key man in it. The institution of the Prime Ministership is the result of a convention. In 1905, the title Prime Minister was noted in a royal warrant and it was later mentioned in the Chequers Estate Act of 1917. The position of Prime Minister was legally recognised after the passage of the Ministers of the Crown Act of 1937. The Prime Minister is central to the life and death of the Cabinet. It is around his figure that a ministry is formed and his death or resignation brings about the automatic fall of the Cabinet. He thus creates, keeps, and destroys the Cabinet. According to the conventions of the country, a Prime Minister must belong to the House of Commons. Appointment of the Prime Minister. The Prime Minister is appointed by the Crown, the King or Queen. After the general election in the country, the King invites the person who has a majority in the House to form the government. We can also say the choice of the Prime Minister is automatic. But sometimes the choice of the Prime Minister can present complications. Complications arise when the Prime Minister dies in office or resigns for personal reasons and the majority party has no recognized leader. In that case, The Queen has the absolute right to consult and summon anyone she pleases. Powers and functions. The following are the powers and important functions of the British Prime Minister. A. Leadership of the Cabinet. The Prime Minister is the leader of his Cabinet. He is the dominant personality in the Cabinet. If the Cabinet is the engine of the ship of the state, the Prime Minister is the driver. He forms the Ministry. He appoints the ministers and can also dismiss them with the approval of the King or Queen. B. The leader of the House of Commons. The Prime Minister is the leader of the House of Commons. He represents the Cabinet in the House of Commons. He is the chief spokesman of the government and all important announcements in the House are made by him. As a leader of the House of Commons, he has the power to correct the errors in the statements issued by his colleagues. C. Source of communication. The Prime Minister is a source of communication between the King and Cabinet. He plays a vital role between the King and Cabinet. The Prime Minister is the mouthpiece of the Cabinet, which conveys his views and decisions to the Crown, and at the same time, he conveys the Crown's messages to the Cabinet. D. Control over foreign affairs. The Prime Minister controls foreign affairs. He formulates foreign policies. He can exchange public messages with the ministers of other countries. The British Prime Minister also attends international conferences. E. National leader. The Prime Minister is the national leader of the country. He makes all policies for his country. He is the leader of his people. F. Control over the finances. The British Prime Minister also controls the finances of the country. The budget is prepared with his knowledge and he is kept informed about the financial affairs. G. Powers of appointment. Important appointments are made by the Crown on the advice of the Prime Minister. He can appoint ambassadors of the country, diplomatic representatives, governor-generals of dominions, governors of colonies, finance ministers, members of the cabinet, civil officers, military officers and church officers. H. Chairman of various bodies. The Prime Minister is the chairman of various bodies. He is the ex officio chairman of the important committees. J. Acknowledged leader of his party. The Prime Minister is the acknowledged leader of his party, which is the majority party in Parliament. K. Chief Advisor of the Crown. The Prime Minister is the Chief Advisor of the Crown. He advises the Crown on important matters. L. Right to choose the date of the election. The Prime Minister is the only person in the British government who decides when to hold a general election, that is, to dissolve Parliament and go to the polls. M. Policy maker. The Prime Minister is the policy maker. All important policies are made by him. N. Power of dissolution. The Prime Minister is the only person authorized to advise the King to dissolve the House of Commons. The Prime Minister should consult the Cabinet on the issue of dissolution. O. Settlement of disputes. The Prime Minister settles disputes between the different departments of the government and privileges of the Crown in Britain. Introduction. The constitutional history of England begins with an absolute monarchy. The King was an absolute sovereign. He was the source of all legal power, but with the passage of time, the powers of the King decreased. Prerogatives are those legal powers that are left with the Crown or that were not taken away from the Crown during the decline in his powers. In the past, prerogative powers were originally exercised by the monarch acting alone and did not require parliamentary consent. They are now always exercised on the advice of the Prime Minister or the Cabinet. There may be situations in which the monarch could choose to exercise the royal prerogative without the advice of the Prime Minister and Cabinet. Such situations are extremely rare and could only occur in emergencies. Difference between the King and the Crown. Following are the differences between the King and the Crown. A. There can be the demise of the King but not of the Crown. B. The Crown is an institution, whereas the King is an individual who holds the institution. C. The king is part of the crown, but the crown is not part of the king. Definition. Following are some important definitions of the prerogative of the crown. A. According to Dicey, a prerogative of the crown signifies those powers that have not been taken away from the monarch during the process of decline in his powers. B. According to Coke, the prerogatives are those powers, preeminence, supremacy, and privileges which the law gives to the crown. C. Simple definition. Prerogatives are common law discretionary, optional, powers of the king. Regulation of the crown's prerogative. The king exercises his prerogatives on the advice of the cabinet. The exercise of prerogative rights, whether by the king himself or by the cabinet, is regulated by the conventions of the Constitution. Limitations on prerogatives. The crown's prerogative is created for the benefit of the people and cannot be exercised to their prejudice. The courts have the authority to ask if any supposed prerogative comes into existence. Present junction. At present, the crown's prerogatives are very restricted. The crown can claim any prerogative that is opposed to common law, any act of parliament, or the liberties of the subjects. Prerogatives of the crown. There was a time when the king had a very large number of prerogatives, but their number has lessened over time. Some of these prerogatives have been taken away by acts of parliament, and others have disappeared because they were not exercised for a long time. The prerogatives of the crown are classified into two categories: personal prerogatives and political prerogatives. A. Personal prerogatives. Following are the personal prerogatives of the crown. 1. The king can do no wrong. By no proceedings known to the law can the king be made personally responsible for any act done by him. In the second place, it means that any illegal act done by anyone, including public servants, in the name of the crown cannot be taken as a defense in the case proceedings. 2. The king is never an infant. It means that the king is never an infant, even when the king is actually an infant. The assent given by him to bills passed by Parliament makes them valid. It is presumed that the king is always fit to transact the business of the state. 3. The king never dies. The king is immortal. As soon as one king dies, he is succeeded by another. B. Political prerogatives. Following are the political prerogatives of the crown. 1. Administrative prerogatives. Administrative prerogatives are listed below. A. The creation of the press. B. The creation of corporations. C. Appointment and dismissal of ministers and other government officials. D. Declaration of war. E. The Crown is the chief command of the armed forces. 2. Ecclesiastical prerogatives. The following are the ecclesiastical prerogatives of the Crown. A. Power of appointment. The king appoints high ecclesiastical officers by using the power of appointment, for example, the appointment of an archbishop. B. Head of church. The Crown is the head of the church in England. 3. Legislative prerogatives. A. Power to legislate. The king has the power of common law to legislate for conquered and ceded colonies. B. Summoning of Parliament. The king has the power to summon the Parliament. C. Dissolution of Parliament. The king has the power to dissolve the Parliament on the advice of the Prime Minister. D. Assent on bills. The king has the prerogative of giving royal assent to bills passed by both houses of Parliament. E. Appointment of peers. The appointments of peers are made by the Crown. 4. Foreign prerogatives. Following are the foreign prerogatives of the Crown. A. Declaration of war and peace. The king can declare war and peace at any time with other countries of the world. B. Appointment of an ambassador. The king appoints the ambassador of his own country, who represents them abroad. C. Representative of the nation. The king is the sole representative of the nation in international dealings. D. Power to make treaties. It is the prerogative of the king to make treaties. Parliament is sovereign with limitations. Introduction. Admittedly, the Parliament of England is the mother of all other parliaments. Other countries have taken their inspiration from her. In the words of de Lolme, the Parliament can do everything but make a woman a man and a woman. The UK Parliament is the oldest institution in the field of legislation. It had sovereignty and supremacy in the UK right from the beginning of the parliamentary era. Meaning of parliamentary sovereignty. The sovereignty of Parliament means that Parliament is the supreme power of the state in the sense that it can make or unmake any law. The courts will obey its legislation in all respects, and there is no power in the state capable of overriding, limiting, or prescribing its authority. Constituent of Parliament. The British Parliament is based on the following institutions. A. The Crown Institution, King or Queen. B. House of Commons. C. House of Lords. Principle of parliamentary sovereignty. Parliamentary sovereignty can be understood by taking into consideration the following principle of the British Constitution. A. The legislative sovereignty of Parliament. B. The complete supremacy of ordinary law through the Constitution. C. The dependence of the Convention upon the law of the Constitution. Exposition of parliamentary sovereignty. Parliamentary sovereignty implies the following three things. A. The right to make and unmake any law. It means that Parliament has the authority to alter or repeal any law. B. No person or body of persons in the UK has a right to override or set aside the legislation of Parliament. No one has the right to break free from the laws made by the Parliament, and certain laws cannot be challenged in court. Because courts have to obey the legislation made by Parliament. C. This authority of Parliament extends to every part of the British dominions. Examples of parliamentary sovereignty. The UK Parliament has gradually attained supremacy with the passage of time. Its supremacy may be discussed under the following headings. A. Supremacy as regarding public rights. The following are included in this heading. 1. Bill of Rights, 1689. The provisions of the bill illustrate how the Parliament becomes the de facto sovereign of the state. The bill says that the election of members of Parliament ought to be free. The power of the King to suspend or disseminate laws without the assent of Parliament is illegal. 2. The Act of Settlement 1701. The Act shows that the King occupies a throne not because he is a member of the royal family, but under parliamentary title. 3. Act of Union with Scotland in 1707 and with Ireland in 1800. By passing these two acts, Parliament made Scotland and Ireland part of the UK. 4. The Parliament Act of 1911. This act curtailed the powers of the House of Lords. All legislative power relating to money bills was taken away from the House of Lords. 5. The Statute of Westminster, 1931. Under this act, the Dominion legislature was granted full legislative authority. B. Supremacy regarding private rights. The Parliament has established its supremacy by interfering with private rights. According to Coke, the following are instances of parliamentary sovereignty. 1. It may adjudge an infant or minor of full age. 2. It may naturalize and be alien. 3. It may legitimize an illegitimate child. Limitation on the sovereignty of Parliament. The following limitations are imposed on parliamentary sovereignty. A. Rule of law. Parliament cannot make a law contrary to the rule of law. If Parliament passes a law opposed to the rule of law, it imperils its own supremacy. B. International laws. It is true that Parliament can pass a law that is against the rules of international law, but ordinarily while interpreting the statutes, courts proceed on the presumption that Parliament did not intend to violate the principle of international law. C. External imitation. The external imitation was due to the possibility of popular resistance. Parliament will hesitate to pass laws that are likely to be opposed by the public. D. Internal imitation. The internal check comes from the nature of sovereign power itself. Parliament, with the history of the 18th century before its eyes, will not tax the colonies, or, as it can be described, will not make laws against the wishes of the people. Statute of Westminster, 1931. The Statute of Westminster imposes all limitation on parliamentary sovereignty. According to this statute, the Dominion Constitution cannot be altered or amended by the Parliament of the UK, except with the consent of the Dominions. Political sovereignty. Parliament cannot act against the wishes of the people. The ultimate rulers of England are the people of England. The voters of England can change the Parliament itself at the time of the next election. Press and public opinion. The press and public opinion are important checks on the sovereignty of Parliament. No Parliament dares pass any law that is opposed by the press or public opinion. Leagues and associations. Leagues and associations formed for political and economic purposes put a limit on the sovereignty of Parliament. They have to be consulted by Parliament before a measure affecting them is passed. It is impossible to ignore those associations.